I hope the American people watched and heard President Obama's speech last night and were reassured. I know I was. There are so many parts, so many things that he covered. I won't try to repeat all those, but I would like to expand on one of the very important matters he raised. And this, I will wear my hat as chairman of the Senate Judiciary Committee. I saw the Supreme Court's 5-4 decision last week in Citizens United versus Federal Election Commission. That decision threatens to allow corporations to drown out the individual voices of hardworking Americans in our elections by overturning years of work in Congress, years of work by both Republicans and Democrats alike in campaign finance laws, by reversing a century of its own Supreme Court precedent. The conservative activist bloc on the Supreme Court reached an unnecessary and improper decision that's going to distort future elections. The Citizens United decision turns the idea of government of and by and for the people on its head. It creates new rights for Wall Street at the expense of Main Street. Congress, on behalf of the American people, struggled for years to enact campaign finance reform. Virtually every American wanted campaign finance reform, and we finally did that in a bipartisan way in the 2002 McCain-Feingold Act. This milestone campaign finance reform strengthened the laws protecting the interests of all Americans by ensuring a fair electoral process. In the 2003 case, McConnell versus the Federal Election Commission, the United States Supreme Court upheld the key provision of the act against a First Amendment challenge. That was consistent with 100 years of judicial precedent law, including a long-standing criminal law prohibiting corporations from contributing to federal election campaigns. Now, only 6 years after upholding 100 years of precedent, a thin majority of the Supreme Court, made possible by President Bush's appointment of Justice Alito, has thrown out important parts of the law, and they've run roughshod over a long line of long-standing court precedent. Mr. President, this is a threat to the rule of law. It overrules congressional efforts to keep powerful, moneyed interests from swamping individual voices and interests. Now, in his confirmation hearing, Justice Alito, I might say under oath, testified that the role of the Supreme Court is a limited role. It has to do what it's supposed to do vigilantly, but also has to be equally vigilant about not stepping over the bounds and invading the authority of Congress. That was then, when he was seeking confirmation. This is now. And as Justice Stevens' dissent makes clear, the narrow majority of the justices, including Justice Alito, substituted their own preferences for those of the duly elected Congress, despite 100 years of their own Supreme Court precedents. This is the most partisan decision since Bush versus Gore. That decision by the activist conservative bloc in the Supreme Court intervened in a presidential election. This decision is broader and more damaging in that they have now decided to intervene in all elections. Last week's decision is only the latest example, but probably the most extreme, of the willingness of a narrow majority of the Supreme Court to render decisions from the bench to suit their own ideological agenda. I believe that the activist conservatives now in the Supreme Court got this decision dramatically wrong as a matter of constitutional interpretation and also of common sense. Corporations are not the same as individual American men and women. They do not have the same rights, the same morals, the same ideals. They do not vote. They do not have the same role in our election as individual citizens. At the core of the First Amendment is the right of individual Americans, individual men and women, to participate in the political process, to speak, and crucially, to be heard. That is what the campaign finance laws were designed to ensure, that American men and women can be heard and fairly participate in elections. Last week's decision puts these inalienable rights at risk by ignoring not only the extensive findings of Congress in passing the law, but also logic and reality. The loud megaphones that can be bought by corporate money can drown out the unamplified voices of individual Americans. The campaign finance laws passed by Congress reflected clear reasoning for treating individuals and their free speech rights differently from corporations and their money. If corporations can use their wealth to make independent expenditures for electioneering, because they're now suddenly being given by 5 people on the Supreme Court constitutional rights in elections, what can prohibit them from contributing directly to campaigns? What principle allows us to bar foreign corporations from likewise engaging in campaign communications? The largest companies garner annual profits of hundreds of billions of dollars. And they're doing this even during one of the greatest financial disasters in our nation's history. If even a fraction of that money were directed toward political activity, those companies would have the financial power to dominate and determine this country's elections and the laws of this country. The risks of this new ruling extend even further. The conservative activist majority in Citizens United fails to make clear whether the new rights is conferred or limited to American corporations or if they apply to foreign corporations. Can the Chinese come in and decide, in effect, American elections? It's hard to envision that this is what the Founding Fathers meant to enshrine in the Constitution when they wrote the First Amendment. It's also hard to understand how these conservative activists who sound incessant alarm bells about the imagined dangers of applying foreign law and recognizing rights for non-citizens in our courts now cannot understand the threat of this encroachment on the very core of our democracy. And I'm also disappointed that justices who, as nominees before the Senate, when they were testifying under oath, proclaimed their belief in judicial modesty and judicial restraint, could so then turn around and brazenly ignore the proper judicial role in so cavalier a manner, overturn Supreme Court precedent and override the rule of law. Mr. President, I cannot remember a time in my 36 years here in the Senate when I've come on this floor to criticize even decisions I disagree with. But this one I am, because it goes to the very core of our democracy. And it will allow major corporations who should have laws written to control their effect on America, instead control America. That's not the America I grew up in. It is not the America that Vermonters believe in, where individuals have a right to speak, but not mega corporations. How did the court come to the opposite conclusion about the rights of corporations to spend unlimited money on elections from that enshrined in our laws and prior Supreme Court decisions? Did we amend the Constitution to somehow equate corporations to people? No, we did not. Nowhere does the Constitution even mention corporations. Did we modify the First Amendment? No. The First Amendment reads as it did 6 years ago. Indeed, as it did 219 years ago, when the Bill of Rights was ratified in the 14th state in the Union, Vermont ratified the Constitution. As Justice Stevens noted in his dissent, the only relevant thing that has changed since Austin McConnell is the composition of the court. Last week's decision and its troubling inconsistency with the court's other interpretations of the Constitution leaves us with serious questions about how to ensure that our elections are not corrupted by unchecked corporate spending. It also reinforces a profound concern I've had about the real-world consequences of the Supreme Court's recent decisions for hard-working Americans, real Americans, on issues like equal pay for equal work. When basically this activist conservative Supreme Court ruled that men could get paid more than women, or the power of Congress under the 14th and 15th Amendment to pass civil rights laws like the Voting Rights Act, or issues thought to be long settled like the meaning of Brown versus Board of Education. The newly constituted Supreme Court seems determined to accrue to itself the powers given by the Constitution to Congress and to rewrite long-established precedents, certainly acting contrary to what these same justices said in their sworn testimony when they were being confirmed. I think, Mr. President, is something that every one of us as Americans have to work to ensure the system of checks and balances envisioned by the founders is not cast aside by the whimsical preferences of 5 justices overriding the rights of 300 million Americans. And again, Mr. President, I can only emphasize on the Supreme Court, I do not recall a time, my 36 years, coming here to speak about Supreme Court decisions I disagree with, even though there have been many. But this is so egregious. As chairman of the Senate Judiciary Committee, I would feel that I was neglecting my duties if I did not come and speak against it.